Welcome with us, everyone. As we saw, this has been an incredibly interesting couple of days. Lots of food for thought. I wish we had more time to ask Mercedes about some very, very important issues that are likely to continue to face us. I'm Professor Malik Dahlan. I am a trustee of the British Institute for International and Comparative Law here in London. I'm also a professor of international law and public policy at Queen Mary University of London. And when I'm trying to mediate ISDS initiatives, I work with Institution Courage for Law and Policy through a joint venture between IQ and Global International Resolvers, along with our Registrar General, Wolf von Kumberg. We've been thinking a lot about this initiative, and we do believe that it's a process. I think when we started thinking about regulating disputes at a seminar at Pepperdine University, we did not expect that it would be this difficult, but we ended up writing a paper, and we saw things all the way from TTIP and TPP breaking down to Brexit to cases in the European Court to the current American administration, and so on and so forth. I want to pay tribute to the support of Harvard University, the Davis Center, the negotiation task force, who gave us a wonderful opportunity to break down the idea behind this initiative, which is essentially, let's look at negotiation theory, party mapping, interests. And it was this time last year that we had the opportunity to really bring practitioners, thinkers, negotiation scientists, and so on and so forth. I'm also grateful to my good friend Yarek for taking on this effort very boldly, and with the ITF, because I think it does help us to connect with the mainstream dispute resolution, ISDS sort of environment. We are proposing something that is somewhat out of the orthodoxy, but at the same time, we're understanding the need. Last but not least, I do want to thank the director of BICO, Professor Spiros Maniatis, for his extreme support and continued support and willingness to be innovative, open-minded at a time where the world is closing down culturally. So I think the type of initiatives he's looked at, whether it's breathing space for contracts after COVID, climate change, AI, World Trade Organization reform, and now this effort shows you that BICO has gone through a revolutionary transformation from that traditional sort of human rights, classical European focus, which I feel tended to be unfair to how much the global outlook to international law needs to be. That is not to say that the efforts that have been done by BICO so far weren't worth commending. Before I start asking our panelists to speak, I'd like to introduce them, and I will allow them to then share with us their remarks, and we can then perhaps entertain a conversation, a back and forth discussion, where we can reflect a little bit on what practicality actually means from this really incredibly important. This panel was designed this way for a reason, to really bring us down into a nice sort of symphony, let's say, middle, and hopefully looking into the future with the next panel. So our first guest, right from China, a dear friend and certainly a luminary in this area, Dr. Zhuhua Wang, who is a partner with Beijing Hangzhou Zhong and Partners. Dr. Wang was the founding partner of Beijing Hangzhou and Partners, former associate dean of the law school of the University of International Business and Economics. Dr. Wang used to hold positions of director of the Committee of International and WTO Legal Affairs of All China Lawyers Association, director of the International Trade and Investment Committee, Anti-Dumping Committee, council member, vice director of Foreign Affairs Commission of Beijing Bar Association. Dr. Wang also serves as executive director of WTO Legal Affairs of China Law Society, China Arbitration Law Society, and director of Chinese Society of International Law. Dr. Wang is a visiting professor of Law School of University of International Business and Economics. He is currently serving as arbitrator on the panel of ICSID, China International Economic and Trade Arbitration Commission, Beijing International Arbitration Center, Shanghai International Arbitration Center, Shenzhen Court of International Arbitration, and others. Dr. Wang had represented clients in various arbitral institutions such as CTAC, HKIAC, SCC, ICC, KLARAC, and others. Dr. Wang also appeared as expert witness on Chinese law in foreign jurisdictions. Dr. Wang has been from time to time appointed as an arbitrator at the Hong Kong International Arbitration Center arbitration proceedings. So I'll start and with that remarkable career and background, and we know that China is in the back of our minds. I'll ask Dr. Wang to please give us his presentation.
Yes. Okay, so thank you very much. So Professor Dalang, can you hear me now?
Yes.
Okay, thank you. Thank you very much. I just feel a little bit ashamed because you read me such a long biography. But anyway, thank you very much. So good evening, everyone. So thank you for inviting me to this webinar. So speaking of the mediation, I think the first thing we should talk about is its importance in dispute settlement process. In China, confrontational method of resolving disputes is not always preferred. As you see, harmony is the most precious. So China's deeply rooted Confucian philosophy emphasized harmony and conflict avoidance. Mediation was not used as an alternative, but an essential and integral part of the dispute resolution system. So in China, it is common practice to resort to mediation when disputes arises or go through a mediation process, even in the arbitral or litigation proceeding to settle the disputes. In the design of ICSID and its practice, the preferred method to solve disputes is also mediation. So Aaron Brotes, the architect of ICSID Convention, he said in 1964 that the role of mediation under the Washington Convention system should be more important than arbitration. There's no doubt that 50 years later, the prediction of this giant in the field of international investment law has not been realized yet. However, more and more attention are now being paid to the effect of mediation, especially by those who have already taken lessons from arbitration in ISDS. In these two cases, in the first one, the Metroclad Corporation versus Mexico, so after winning the case, the CEO of Metroclad noted that the arbitration had been so dissatisfying because it spanned approximately 5 years, and claimants incurred estimated $4 million in direct and indirect costs. So the nominal winner is often a real loser. And in the second case, in the Akima BV versus Slovakia case, the tribunal remarked at the close of the hearing that it had a sense that in this case, settlement would be a good thing, because aims of both sides seem to be approximately alike, and the black and white solution of the legal decision in which one side wins and the other side loses is not the optimum outcome in this case. According to statistics from 1966 to 2020, only 12 out of 786 cases are registered on the basis of the exit convention conciliation rules, or the additional facility conciliation rules. And only 5% of exit cases are finally settled. However, with the rapid development of conciliation mechanism in international investment disputes in recent years, we seem to be in the right track to get closer to what Aaron Brothers envisioned 50 years ago. Two of the exit cases involving Chinese government and investor, the Beijing Urban Construction Group Company versus Republic of Yemen, and the Ikaran Berhad versus Republic of China, these two cases were all announced to be discontinued according to exit arbitration rules 43.1. So that suggests a high possibility of settlement of the cases through mediation. China signed a total number of 149 BIT bids and MITs with other countries. Among them, conciliation is used as a method to solve the investment dispute. However, it takes up only a small percentage of the total number of BITs signed. So why mediation has not played a more active role in ISDS has been a subject of many research institutes and also our clients. The National University of Singapore Center for International Law, they conducted a survey which revealed the challenges mediation has been facing, is now facing. For instance, the desire to defer responsibility, media coverage, public criticism, fear, difficult to obtain budget, highly sensitive, and also sometimes agreement may prove impossible. But however, mediation has always been taken as a very important process. And also people in favor of mediation, they have lots of theories like legitimacy, because the mediation concerns about the legitimacy of private arbitrators rendering a decision against the state's regulatory acts. Mediation also allows for broader economic goals, appropriately construing the positive impact investment projects can have for both the investor and the host state, and avoiding the escalation of politically sensitive disputes. And also, there's a certainty of settlement, because the settlement's tangible and certain, and a settlement agreement is easier to be enforced. And also, mediation can preserve relationships. Mediation also helps to shape business and policy considerations, and also the confidentiality, which our keynote speaker just mentioned. So now let me turn to some developments of mediation in ISDS. So in 2018, ICSID began work on a new set of mediation rules. I think everybody knows it. And should parties reach an amicable settlement through mediation, this may be incorporated into a tribunal award pursuant to exit arbitration rules 43.2. So the settlement would then benefit from the simplified enforcement mechanism unique to exit convention. And now we'll talk about Singapore Convention. The inclusion of Article 8 in Singapore Convention should be viewed positively, as the Ancestral Working Group 2 noted that government entities should not be automatically excluded from the Singapore Convention. And also, therefore, they suggested that states who intended to opt out could do so by making a reservation under Article 8. It is worth noting that only 3 states, Saudi Arabia, Belarus, and Iran, out of the 59 states that have signed or ratified the convention, have made reservations under Article 8. So we conclude that states will carry out their commitments to enforce mediated settlement agreements in ISDS. Regarding Chinese practice, in mainland China signed investment agreements of the mainland and Hong Kong closer economic partnership agreement with Hong Kong, and also the investment agreement of mainland and Macau close economic partnership agreement with Macau. Disputes between Hong Kong or Macau investors and the mainland authorities or institutions may be resolved by submitting the disputes to a mediation institution of the mainland side. So CTAC is the mediation institution, and it has published its mediation rules for investment disputes under the CEPA investment agreements. Last year, China also made some proposals in the ISDS reform and the ASTRA reform. Among the proposals China made is to adopt alternative dispute resolution measures. China believes, in contrast with the investment arbitration, investment conciliation emphasizes the value of harmony and can offer the host country and the investors a high degree of flexibility and autonomy. You could find that in the Chinese government's proposal. And China believes that the establishment of a more effective investment conciliation mechanism should be actively explored. So looking to the future, the following measures may be adopted in the future to make mediation more preferred in order to better solve the IS disputes. First, utilizing the mediator's proposal. A mediator's proposal is one proposal to all parties, usually when there is an impasse or stuck point in the bargaining. So if both parties accept, settlement occurs. If either rejects, bargaining continues. Second, appreciating the value of an unsettled mediation. This is important, I think. An unsettled mediation can also yield benefits, such as a better understanding of the dispute and interests involved, a chance to evaluate the opposing side's counsel, and an opportunity to assess the merits of each side's arguments. And of course, appointing the right mediator. And fourth point, which is quite controversial, a mandatory investor-state mediation. The rise of investment arbitration was largely caused by investment treaties that provided for arbitration for the resolution of investor-state disputes. So parties often need a little bit push to try new things. So mandating mediation for certain types of investment disputes, such as those disputes below or above a certain financial threshold, may encourage parties to embrace mediation and use it for a wider range of investment disputes. So the incentive to consider mediation mechanism is worthwhile for all the parties. So thank you for your time and patience. That's all.
Dr. Wang, thank you very much for the presentation. And before I turn to our next speaker, can I ask you a follow-up point?
Yeah, sure.
One of the, I would like to have your reflection about two confusing points for Western lawyers when dealing with China.
Okay.
One is the concept of harmony. I have tried to describe in the Belt and Road Initiative documents and the forum and so on, and it wasn't something, even though like in the US, they have the concept of efficiency, which was made into doctrine. But it seems that there is a resistance. In fact, even my paper originally was rejected by Bickle's editorial board. But I managed to publish it at the Harvard International Law Journal, which is a good thing. But why is it, what does it mean and why is it challenging? The other point is about the Belt and Road Initiative. It seems that what people tend to perceive is there are a lot of rules, a lot of institutions coming into the pipeline in China that provide mediation, but there is an uncertainty or there isn't a clear understanding of how it works with the BIT or the Belt and Road Initiative cases. And in fact, the classification of cases is becoming complicated between what's an investor-state dispute settlement and what's a commercial settlement. Can you give us just a few words about those two rather large themes?
Yeah, they are really very good and big questions. So it's certainly it's very important to understand the word of harmony resulting from the traditional Chinese culture. So if you fully understand the Oriental culture, okay, so the Chinese people don't like to fight. They don't like they don't like litigation and sometimes arbitration. Usually they would, according to the traditional Chinese culture, they would usually, engage someone who is of very important, sometimes a senior or sometimes of high morality, and sometimes very powerful, ask the third person to do the conciliation or mediation work. So, or even give out kind of proposal for both parties to accept. So that usually happens, and that usually works very well. So I think that's rooted in the tradition, Chinese tradition. So as I mentioned just now, the Confucian philosophy, harmony. So they want to try to avoid conflicts. I think that's that's the first thing. And the second thing, when we say that the foreign investors or would like to try to understand the Chinese culture before they understand how mediation is important in China. And on the contrary, I would like to say, like, Chinese people or even Chinese investors, they should also understand the culture in host countries.
Of course.
And that will help the investors and host countries, and also that will finally help the success of their projects. Of course, your question is very, very big, and I'm not going to take up too much time. So maybe in the discussion we could do it. Thank you very much.
Well, I appreciate that. Thank you so much for that answer. And it makes us think about cultural intelligence, as Mercedes also said, is very important. Our next guest is also a looming figure, the Honorable Barry Lyon of 33 Bedford Row. Barry, a Canadian, so mediator by nationality, or a neutral by nationality, is an independent arbitrator and mediator. Barry is a fellow of the Chartered Institute of Arbitrators and an International Mediation Institute certified mediator. He is experienced in arbitrating and mediating corporate and commercial, contract, shareholder, and business breakup construction, natural resources, IP, and technology disputes. Barry was the presiding judge, Commercial Division, Eastern Caribbean Supreme Court in the territory of the Virgin Islands, known as the BVI Commercial Court, from 2015 to 2018. In that capacity, he presided over a range of international commercial disputes involving parties from around the world, including shareholder and corporate dispute, insolvency matters, contractual disputes, fraud and asset recovery proceedings, judgment enforcement and arbitration assistance, and arbitral award enforcement. Prior to his appointment to the court for a 3-year term, from 2009 to 2015, Barry was a partner and head of the International Arbitration Group at Perley Robertson Hill and McDougall LLP, a leading international arbitration law firm based in Ottawa, Canada. He's an arbitrator with 33 Bedford Row in London, arbitration place in Canada, and Caribbean arbitrators in the British Virgin Islands. Also, Barry is an arbitrator on the American Arbitration Association national roster of arbitrators. Welcome with us, Barry. The famous mute unmute moment.
Let's try again. It may sound better muted. Thanks, Malik. I'm going to talk about two policy and practical issues in investor-state mediation. The first is, to what extent does the avoidance of criticism for settling is a factor to inhibit states from pursuing settlement? And if it remains a factor, what else can be done to mitigate that impediment? This was discussed briefly yesterday, and I'll hearken back to a few things that were said yesterday. The second thing I will speak about briefly is whether states have or should be taken to have a responsibility to assess investors' claims in good faith, and if considered to be of merit, to attempt in good faith to negotiate, either directly or through the use of mediation, a fair and timely settlement. It's on the theory that fighting an unmeritorious claim is inappropriate for a state. Before getting into those topics, there has been mention yesterday and today about the involvement of Harvard in the current initiatives. And it was interesting because my introduction to mediation decades ago was when I attended Roger Fisher's 1-week negotiation course as part of the Harvard summer program. The week was all about negotiation. Then on Friday, the 5th day, Roger talked about mediation for the first time. And of course, we learned more about assisted negotiation. It became clear that much of the work that Roger and his colleagues involving states and public international disputes, the subject matter of the great engaging stories that Roger told, some of which are in Getting to Yes and in other books and courses that he and his colleagues taught. Although not commercial or investment disputes, it was mediation work with states. Sometimes they were invited by both sides, sometimes by one side, and sometimes by neither side. They just became officious intermeddlers. The avoidance of criticism factor. Turning to that factor, I'm referring to the governments of the day and the individuals working for the government, for the state, who are responsible for responding to the investor's claim, feeling that it is safer to let the arbitration run its course, and blaming the tribunal if the case is lost. It's safer than being criticized for settling, or worse, being accused of corruption in relation to the agreement to settle. A few weeks ago, this concern about states mediating investors' claims was raised with me in part of an arbitration course I was teaching by a senior official in the government of a significant Asian state. It reminded me that this is still very much a concern of state officials. I first became interested in this topic when my former colleague, John Terry of Tories in Canada, and I wrote a chapter for the first edition of the American Arbitration Association's handbook on international arbitration and ADR. That was early 2006. It's now in its third edition. In our chapter, which is why arbitrating against a state is different, which is now called 13 Key Reasons. In the first edition, we just had 12 reasons, as I recall. That, and I'll mention some of the thoughts that we had at that time and I continue to have. My interest continued when I worked on the committee that developed the IBA rules for investor-state mediation, which were launched in 2012. And what was, I think, most interesting about that experience is that the committee was chaired by, and each of the subcommittees were chaired by, and the members of those subcommittees consisted of roughly an equal representation of state representatives and private sector representatives. Government employees who decide how a state will respond in arbitration may face pressures and restrictions that differ in nature and degree from those faced by employees in commercial entities. The pressures may be greater when the arbitration has a public profile, which often is the case. For example, employees may feel pressure to raise every possible argument to avoid being criticized for not doing so. This ties into the second topic of a state's responsibilities. The incremental cost of pursuing weak arguments will be less apparent and less significant than an unfavorable award or settlement. If a weak argument is pressed but lost, blame can be attributed to the tribunal. Government employees may also feel pressure to delay the issuance of a final award in a losing cause. Delay may take the case out of the limelight and reduce its public profile by the time the final award is issued. Yesterday, Wolf spoke about the fact that government leaders of the day and bureaucrats have an easier time with adjudicated decisions. They don't own it in the same way as they own an agreement which they have made. Even though I would say they can and should be criticized for their conduct of arbitration, for poor strategies and tactics, where that has brought about a bad result. But they can always say, as I mentioned earlier, the tribunal didn't get it, we should have won, and so on. Yesterday, when talking about this subject in response to a question I asked, Meg Kinnear spoke about kicking the can down the road. She said that rather than mediating, state officials may see it as advantageous to kick the can down the road by staying in arbitration. She explained that this avoids them having to deal with a dispute. Her suggestion to assist with this problem included states and state officials needing to understand and appreciate and be able to explain to others that entering into mediation is not showing weakness, why it is advantageous to mediate, and why entering mediation is a positive. State and state officials also need to understand, appreciate, and be able to explain to others, both generally and in the context of a particular claim, why settling and why a particular settlement may be, or is, preferable to an adjudicated outcome. Of course, that can be a challenge for a state, and indeed for any organization, when implicit in having to pay money or make concessions to a claimant is that some conduct of the state or of the organization, and particular individuals in that organization, brought about the situation. They erred, they misjudged, or worse. And it's even a greater challenge when the public, media, opposition parties, civil society, and others may be critical for both legitimate or, in some instances, self-serving reasons. The second significant aspect of avoiding criticism for settling bites even harder, and that is where there's a restriction on state employees in some countries in anti-corruption rules. These rules can go so far as to make it illegal for state employees to voluntarily settle a dispute on behalf of the state. A failure to prosecute all of the state's possible arguments could result in personal criminal liability. Meg spoke about this point yesterday too, suggesting that to protect individuals involved in mediation on behalf of the state from personal exposure, first, changes in domestic legal frameworks are needed in some cases, but she noted that that is early days for these efforts. Second, the ICSID mediation rules will provide that a state official, preferably a senior official, comes to the mediation to say that we are authorized to enter into the mediation. By doing so, the senior official is making it clear that entering into mediation is a government action, not that of the individual. Alejandro also spoke about this yesterday when he spoke about the value of states entering into mediation and the importance of identifying a state representative and describing the approval process for any settlement reached. But more creative brainstorming is needed. Those solutions, I would submit, are only partial solutions. This is a fundamental impediment to mediation, and it needs to be tackled with more thought, more creative ideas. We have the ideas that I mentioned, that Meg and Alejandro mentioned, education and training, so that there's an appreciation of the mediation process by those involved and by the public. Measures to protect individuals who are involved in the mediation on behalf of the state. And third, Meg mentioned this in a different context, but success stories. That is to demonstrate to those who drive the bus on settlement, whether through mediation or direct negotiations, that there can be positive outcomes in the interests of the state, and that there should not be a suspicious, self-serving conduct attributed to those who are involved in the process. Yes, as we know, changing broadly accepted attitudes and cultural perspectives is not easy, nor is it fast. So we need other ideas. It would be great if others on this panel and others in this forum have ideas. Time permitting, a bit of group brainstorming would be useful. Perhaps some future separate brainstorming session would yield ideas. But what seems clear is that this is a real impediment, and tackling it will give a boost to mediation in ISDS. The second topic that I'm going to mention briefly is the subject of a state's responsibility when responding to investors' claims. Whether states have or should have a responsibility, first to assess the investor's claim in good faith, and if it is considered to be of merit, secondly, to attempt to negotiate in good faith, either directly or through mediation, a fair and timely settlement. As I mentioned earlier, the theory behind this is that fighting an unmeritorious claim is inappropriate for a state, and that this should be or become the culture of states involved in particularly investor-state disputes. My interest in this topic comes from studying a pending investor claim against a developed state, which has received public attention, in which it appears, at least to an outsider, that findings of serious criminal wrongdoing in proceedings in the state's courts occurred, and it strongly suggests that there is merit in the investor's claim. Yet the state is vigorously defending the proceedings. One never knows, of course, what's behind it, but to an outsider, it leaves a bad taste in looking at the conduct of states when that is the perception that exists. It bites in different ways in different situations, but I submit it's something that could be and should be talked about more. On that note, I will conclude, Malik, and if there's any questions, happy to take them.
Thank you, Your Honor. I think we're a little bit stuck with time, but I want to leave you with a thought for you to consider. You mentioned Roger, the late Roger Fisher, who was also my supervisor, but I wonder, to what extent do you think the time has come to really rethink the philosophical foundations of ISDS from an international legal point of view. In other words, ideas about state immunity and most favored nation, all of these complicated issues. I know one of the main things that we tried to tease out, and it was a struggle, is to bring the investor, you know, the big investors like the major oils or you know, we're just latching onto the idea of protecting the investment in the investor. And the states, on the other hand, are just not engaging. But sorry, I'm leaving this, but let's use a host state, but I'm hoping that it'll come up in the Q&A. I have with us someone who represents a host state. So this is wonderful. A lawyer who's young and is quickly understanding the challenges. So Igun Ilire is the head of legal analysis and expertise division in the Ministry of Energy of the Republic of Azerbaijan. Beginning her career as a civil servant in 2010, Igun held various positions in the ministry and was appointed to division head in September 2018. Since the beginning of her career, Igun was involved in numerous projects aiming to develop institutional and legal framework of the energy sector. In her current position, Igun ensures bilateral cooperation with international financial institutions and foreign investors in implementation of essential projects, as well as providing legal support thereof in the light of pending fundamental reforms in the energy sector of the country. While performing the secondment program in the ACT, she successfully accomplished the development of recommendations in prevention and management of investment disputes, exploring international best practice in dispute settlement. She plays a key role in the cooperation with the International Energy Charter and takes an active part and represents Azerbaijan in the energy charter process, including modernization process. Welcome, Igun.
Thank you, Dr. Dahlan. I would like to share my presentation. Thank you, and good afternoon, good evening to all our distinguished panelists and participants of this interesting discussions, very interesting. Today I will talk about mediation in Azerbaijan. First of all, I would like to say that I would like to give some information about Azerbaijan climate in dispute settlements. Last year, with the Ministry of Energy, during my secondment at the Secretariat, with Energy Charter Secretariat, we developed recommendations called Prevention and Management of Investment Disputes in Azerbaijan, based on the model instrument on investment dispute management developed by the Secretariat. As a result of the study we undertook, it was clear that there are very few cases against Azerbaijan. This is a very interesting point because Azerbaijan is, as we all know, Azerbaijan is energy investor and also producer country. This information was taken from the ICST and United Nations Conference on Trade and Development. As you can see, there are different nations sued Azerbaijan. During our study, we discovered many challenges in this sector. As I mentioned, there are very few cases. That's why legal legislation and legal framework is not so very much developed in Azerbaijan. So the first challenge we met is there is no centralized entity for the coordination, management, and representation of the Azerbaijan regarding foreign investment disputes. Ministry of Economy is in charge of the investment policy of Azerbaijan as a central executive body, but it's not precisely authorized to represent Azerbaijan in such disputes. Also, there is no centralized entity in charge of strategic communications, including press statements, meetings with investors, and communications with other stakeholders related to investment disputes. Because each public body in Azerbaijan has its press secretary, but there is no one responsible body who will communicate with investors. The third challenge I would like to mention, Azerbaijan's current legislation doesn't contain precise arrangements for amicable dispute settlement of investment disputes, and informal practices lack clear regulations. Of course, in the legislation, in laws like protection of foreign investments, there are provisions, but these provisions are very general. So there is no mechanisms for applying these provisions. Fourth is there is no centralized database with international investment agreements and investment contracts in force. There are many databases in Azerbaijan, like State Registry of Legal Acts. As we know, international agreements are confirmed by law, and everybody is freely can access to these registries. But the disadvantages of these databases like this are in Azerbaijan, only in Azerbaijan, and of course there are no central database with previous conflicts, disputes with foreign investors, identifying the specific sectors triggering conflicts with investors, the nature of the conflict, and how it will solve. Now I will like to give some information about recommendations we propose to the government of Azerbaijan in this document. First of all, strengthening the authority of the body responsible for coordinating and managing investment disputes. We identified the Ministry of Economy because we have very few cases in investment disputes, and to create, establish another separately public body is not necessary. So the Ministry of Economy could be explicitly granted the function to coordinate and manage international investment disputes. On the other hand, to consider a binding regulation, act or decree summarizing all relevant aspects of the prevention and management of investment disputes to facilitate transparency and better understanding by all government officials involved and foreign investors. Secondly, development of the early warning mechanism. As we know, this is a very important part of this disputes resolutions. To set a duty for state entities that are notified or otherwise becomes aware of the existence or likelihood of an international investment dispute involving the Azerbaijan to notify the responsible body in written immediately. Thirdly, promotion of amicable dispute resolution mechanisms. To authorize Ministry of Economy to manage investment disputes, including matters relating to contracting of legal counsel, experts, and external advisors in accordance with the regulations in force governing public procurement, and also to grant settlement authority for the purposes of the negotiation and conclusion of settlement agreements with foreign investors. Public access to information, confidentiality, and strategic communication. As I mentioned, there are only press secretaries of each state body, but to assign the Ministry of Economy as a sole official spokesperson would be very significant and helping suitable for Azerbaijan. On the other side, to prohibit other civil servants from public statements and press media releases about conflict disputes with foreign investors, and at least establishment of a model dispute resolution clause for international agreements and contracts with foreign investors. As Azerbaijan has many international investment agreements with countries, with foreign countries, bilateral agreements, but the contracts with foreign investors are in the format of product sharing agreements and also private, public-private agreements. And these contracts don't have model dispute resolution. These are very different from each other. Now, I would like to give some information about law on mediation. Azerbaijan has approved a law in 2019. As mediation is a very new concept for Azerbaijan because there are very significant reasons why mediation comes so late to Azerbaijan. Before the adoption of the mediation law, Azerbaijani legislation almost didn't refer to mediation, and the concept of mediation was quite alien for the legal system in Azerbaijan. In practice, there were very few mediators offering mediation services in Azerbaijan, and none of them were full-time mediators. On the other hand, Azerbaijani courts are one of the fastest courts in the Council of Europe region, and fees for attorneys and courts are extremely low. Accordingly, the parties didn't have strong incentive to settle disputes out of court. However, Azerbaijani courts are overwhelmed with huge number of incoming cases with very strict deadlines for adoption of decisions, which damages quality of judicial justice in Azerbaijan. Mediation could decrease number of incoming cases and thus contribute to the quality of justice by allowing courts to concentrate more on other cases. It will subsequently also decrease enforcement cases as settlement agreements mutually agreed by the parties will mostly be performed voluntarily. In addition, as there is unpredictability and no established court practice in connection with litigation of most disputes, mediation will allow the parties to control their litigation risks and to avoid unpredictable outcomes of court proceedings. I would like here to mention that this law was developed with the support of European Union and taken into account the best global international practice. Now I would like to give some information about this law, what this law regulates. This law regulates, promotes the use of mediation in civil and commercial disputes, also disputes with foreign elements. Disputes arise now out of family relations, labor relations, and administrative legal relations. The disadvantage of this law in the framework of investor-state disputes is that in this law precisely doesn't be stipulated that this law also applies to investor-state disputes, just commercial disputes. Principles of mediation in the law is like that voluntariness, legal equality and cooperation of the parties, impartiality and independence of mediators, inadmissibility of intervention in mediation process, and of course confidentiality. Any person not younger than 25 years with higher education and 3-year work experience may become a mediator after obtaining initial mediation training certificate. Under the law, mediators, mediation organization, and mediating training companies are going to be regulated by a self-regulated authority called the Mediation Council. Of course, the mediation, if a mediator wants to conduct this function, he or she should be a member of the Mediation Council. And also, the law also regulates how cases will be referred to mediation. One of the interesting points of this law that there are mandatory initial mediation sessions in the law referring to commercial, family, and labor disputes. Before going to the courts, participants have to take part in the initial mediation session. At the initial mediation session, the mediator explains the essence, advantages, and rules of the mediation process to the parties, conducts joint and separate meetings with the parties. The parties decide if they want to proceed with mediation process.
Egan, I apologize for cutting you off. It's really my fault that I ran over. But do you mind if we, we pick that up in the question and answer section? I know we're stuck with time, but I take full responsibility for that.
I should stop here or just?
Yeah, this is absolutely fine, and I apologize for that.
No, it's okay, no problem.
Alexander, do you want me to fully introduce you, or I will do to the introduction then. Alexanderov is a partner at Sherman and Sterling. He is a partner of the firm's international arbitration practice. He provides advice and representation to corporations, states, and state-owned entities in complex international commercial and investment treaty arbitrations. His experience covers a wide range of subject matters and industries with an emphasis on energy, natural resources, and infrastructure-related disputes. He has conducted arbitrations under the ICSID, ICC, LCIA, CRCICA, and CAS rules, as well as ad hoc arbitrations, including under the UNCITRAL rules. He is recognized as a future leader in international arbitration by Who's Who, Legal 2018, 2019, and 2020. The 2020 edition reports that he in international arbitration is a name, it calls him a named term member in investment treaty arbitration, according to peers who applaud his great commercial sense. He is also included on the Legal 500 International Arbitration Power List, United Kingdom. I had to introduce you, even though I took some of your speaking time.
Okay, well, thank you very much, Malik. I think a short introduction is quite sufficient. Let me also briefly thank Jarek and the rest of the BICL organizers. And let me start by saying, I've been asked on this panel to give a practitioner's perspective. And the session, of course, is titled Between Policy and Practical Issues. When as I understand it, practitioner's perspective in this instance is being used as a proxy, particularly for the investor's perspective, which we haven't heard a great deal of yet. For that purpose, let me say, at Sherman and Sterling in my own practice, we act for states as often as we act for investors. So don't think my remarks are one-sided or other, but I have been asked for this purpose to take particularly the investors' part of the view and to provide that level of input for this session. And as we will see, I'm going to make a motto of my presentation, the motto of the US state of Missouri. Let me also say, by way of introduction, I've really got two roles as a partner in an arbitration practice. The majority of the work I do is obviously conducting arbitrations, including arbitrations, as I've said, both for and against states. But a significant minority of the work I do is upstream of that, structuring dispute resolution mechanisms, working alongside the transactional practices of my firm, particularly project finance, advising them, how are we going to make this work? What will happen if a project goes wrong, if we have to sue someone? So I have really sat in the room while these issues are negotiated in order to set up a project. I also wanted to say, by way of introduction, that my work, Sherman and Sterling's work, and I think that's typical of any dispute resolution lawyer, is all about outcomes. We do not litigate for litigation's sake. That the best advertisement for a lawyer is to get the best outcome for his or her client, and that may be through bringing an investment treaty claim. We are entirely open-minded to any alternative that will get our client the outcome that it wants. And I think it's really important to bear that in mind. We will actively pursue whatever means will get the best result for our client. Right, pausing there, I think the first point to talk about to understand an investor's perspective here is to think about a typical project finance structure and who are the stakeholders in that. And keep in mind, these are often very major projects with investments in the hundreds of millions of dollars, even billions of dollars. They are very high stakes, carefully conceived projects. They take a long time to build, to conceive, to build, to set up. But who are the main players in this? Obviously, there's the project company, who is the investor, usually for this purpose. There may be other investors as well. But generally speaking, you have a project company who signs the agreements, executes the project. Then you have the sponsors, who are usually the owners of the project company, would provide equity financing, provide know-how, usually have experience and technology that is relevant to the project. And then also, very important, you have the project lenders. This is the debt financing provided by commercial banks, development finance institutions, and they play a hugely important role. And crucially, when it's the lenders who have all sorts of rights. The project is usually pledged, the project assets are pledged. They have rights to step in to take the place of the project company if there's a default. That's very important to keep in mind. And it is the project, when you have a dispute or a problem with the project, it's the project company who has to go and report back to the lenders, to the sponsors. And once again, in my practical experience, I have been sat in the room when the project company has to convene a meeting of its lenders and say, I'm terribly sorry, fellas, I'm not going to be able to pay you on time. And the project company is coming to ask the lenders essentially to waive their rights to grant it an extension. And of course, lenders are commercially rational people. They will act reasonably, but they're going to need some pretty good reasons to waive their rights and to understand exactly what's going on and to satisfy themselves that the project company is acting in a sensible, rational way. Now, this all brings me to my next point. What do investors want? And that really is very simple. All investors want is to finish their project and start earning a return on their investment as quickly as possible. It's really simple. And that's in the project company's interests, it's in the sponsor's interests, and it's certainly in the lender's interests. Everybody wants to start getting paid back as soon as possible. And for that, they want to finish their project, start producing whatever they produce, and repaying their loans, earning a return on their investment. And really crucially for this, time is money. Very literally, a lot of companies would have an internal rate of return of say 8%, 10% a year. So starting to earn a return on their investment is really crucially important, and delay is very bad news for the project company and for the investors. So my second takeaway then, investors will welcome anything that will improve the prospects of the successful and timely completion of their project. And that would include any kind of mediation. My third takeaway, and I will come back to mediation a bit. Third takeaway, investor-state arbitration is really the worst possible outcome for a project. And I know you've discussed this a bit yesterday, but for just to briefly go back over some of those reasons, I mean, it is sometimes described as a nuclear option. And that's for a good reason. It really does have a serious impact on the relationship between the project, the sponsors, and the host state. And that is something investors are very cautious about. They're very conscious of. Equally, as has already been discussed, investment treaty arbitration is very expensive and it's very slow. Average costs per party for investment treaty arbitration are in the region of $5 million, could well be much higher than that. And the average duration of an investment treaty arbitration is in the region of 4 years. If you add on, say, another 2 years for an annulment proceeding, and then you have to fight about enforcement after that, you can be looking at not getting any money back for 6, possibly 8 years. And as I've said, time is money. That is an awfully long time to wait to earn any return on investment. So bringing me back then to mediation. And as I've said, investors will welcome at any development that genuinely improves the chances of a successful outcome, and will allow their project to progress. And equally, investors really are reluctant to sue states where they see a viable alternative to that. And these are factors which really weigh strongly in favor of using mediation where it's available. Let me also say, mediation is much better suited to the kind of non-financial outcomes which might help a project to go forward. Contrast that with the Article 54 of the ICSID Convention, which is the enforcement provision, which says, each contracting state shall recognize an award and enforce the pecuniary obligations imposed by that award. So when you're in an investor state situation, then you really are, by and large, only talking about money. And it is often the case that money is not going to be the best answer to the dispute that the parties the parties have. Now, this brings me quickly back to what I foreshadowed at the beginning, the state motto for the US state of Missouri, which came from an 1899 speech given by Congressman Van Diver. And what he said, and I think it's important in this context, frothy eloquence neither convinces nor satisfies me. I am from Missouri. You have got to show me. And the show me state now features on every car license plate in the state of Missouri. And I really think that's important here. As I've said, investors will be open-minded to anything that will improve the likelihood of a good outcome, but really show me that this is going to work. And a particular reason I say this is that, we've talked about political buy-in and getting the attention of the government. Investors are already doing that. This is part of the design, the conception of any project that that I've seen. And there are various ways to get the government's attention, to get the government's buy-in upstream. You can give the government a stake in the project. You can have concession agreements or other contracts with the government. I have negotiated projects with specific government support agreements. Really, investors are desperate and will do everything they can to get as much assurance as possible that the government supports the project. Even for smaller scale projects where specific agreements aren't possible, investors spend really large amounts of money on political consultants, on lobbyists, and really are making huge efforts to get the attention of the government, to get that buy-in already. So I really think there is a relevant question. How is this going to make a difference? What is going to tip the balance for to get government buy-in where that's not working already, despite the efforts of investors? And so, yes, we absolutely embrace a discussion about mediation, but it does need to be more than, to hark back to Missouri, more than frothy words. And let me just finish with a few comments on how to make it effective. And I appreciate this has been discussed already. There obviously is a degree of political reluctance and political responsibility taking, and I know Barry's addressed that. That does genuinely seem to be more of a concern on the state side than the investor side, and that for understandable and legitimate reasons. Can the state really bring together all the necessary stakeholders, government departments? Are we speaking to the right person who represents the state and has power to give commitments by the state? What comfort could we get that a mediation isn't just being used as a device to create delay, to postpone a dispute, to kick the can down the road, as the phrase has been used? How often do disputes receive any meaningful discussion during a cooling off period before starting an investment treaty claim? Equally in that regard, I think one solution potentially is to run a mediation in parallel with starting an arbitration, and that at least avoids any suspicions that it's being used purely for delay. Another issue is, are we sure that outcomes are going to be observed? How do we get comfortable that a settlement agreement pursuant to a mediation will be observed by the state, particularly where it's a long-term relationship? Projects can last 10, 20 years following their completion. There will be changes of government, changes of political priorities. Can we get enough comfort that the agreement will stand all that? And last, and this picks up a little from the points that Egon was making, I just ask, should we be limiting this discussion to mediation? Because what I've said is, investors from an early stage are trying to get government's attention. Should we not focus as much on dispute avoidance as nipping disputes in the bud before they become fully contentious? And just to say, I do think having an early warning system, as Azerbaijan apparently is considering, would be a great help in that respect. So let me end my remarks there. I appreciate we're still short of time, so thank you very much and happy to take any questions.
Well, this is excellent. Here we go. We heard it from the lawyers, so I don't think it's quite as adversarial as we had worried. What I'm going to do, because I don't see questions, what I'm going to do is give each one of our panelists 2 minutes, just because I think everyone needs a break before the next session. And I'll start with Egon, and my apologies again for cutting you off. The state has to be the one that takes it. Can you unmute, please?
Thank you, Dr. Dahlan. It's not problem. It's everything it's not problem really. These circumstances we live through is very harsh now, and it's understandable. What I would like to conclude my speech is that I am very new in mediation because, as I said, it's very new for Azerbaijan. and also we are developing this sector because in the framework of reforms in Azerbaijan in the courts. As I am joining the thoughts my colleagues stated that state should be take responsibility, of course, and for that early warning mechanism is very useful mechanism, useful mean. But on the other side, state should also provide, regulate its relations, expressly know what the mechanism, how to answer the investor. And Azerbaijan works in this direction. Thank you once more time for this.
Thank you so much. And the dialogue we continue, and hopefully better year ahead of us. Dr. Wang. I think you need to unmute.
Yeah, exactly. Thank you, thanks. I'm sorry. So the Singapore Convention enhances the attractiveness of mediation by allowing international mediated settlement agreements to be enforced across national borders. So the incentive to consider mediation, I think, is worthwhile. It's worthwhile for all the parties, especially when Asian countries are involved. That's it.
Thank you very much, Dr. Wang. And I think it's very, very important to, as you said, there was no reservation from China's side. So I think to me, that's a great indication. Your Honor.
You mean Barry?
Barry.
Malik, there is one question, just to call it to your attention there. But what I was going to say with my 2 minutes is that I think the concepts, Alexander mentioned it and Ayan mentioned it, others have mentioned it yesterday, steps out the early warning mechanism, the dispute avoidance mechanism, which is gaining a lot of traction in areas like construction. And somebody mentioned yesterday, states treating investors as customers or clients and being sensitive when they're taking regulatory measures or making changes, not to take account of the state's needs, to talk with them as one would with a customer, an important customer. And I think those kinds of measures can do a lot to avoid the disputes and deal with the problems before they become disputes.
That's becoming a theme about dispute avoidance and management and regulation, as Wolf calls it. I would like to promote one of the questions that came up here from Herman Verbist, and I think Alexander is more fit to answer this, but we shall see. Can I have him ask the question, or do you want to just go ahead, Alexander? Can't see the code.
Why doesn't he ask the question?
I don't see it. Here we go.
Who will, from the investor's perspective, who will participate?
Yes, and you have to show us, as we say in Missouri, not Missouri.
Missouri.
Hi, sorry. Yes, it was my question. If you don't mind, I can just formulate it orally to the listeners. Yeah. So I was indeed curious, and that was particularly for you, my colleague, because indeed in investment arbitration, you raised it. Indeed, you have lenders, you have the project company. Sometimes also you have third-party funders, right? And particularly from the investor side, then the question is, if you go to an investment mediation, who will, after all, decide about going to investment mediation? Would it be the project company? Would it be the lenders? Would it be the third-party funders? And sometimes they may have different views, conflicts, so different interests also. Could you just maybe tell us a bit on how that would go? So on taking the step, well, it doesn't happen very often in practice, but the question also then would be, who would be say, the most difficult to convince in order to step into a mediation? Would it be the lender? Would he be more reluctant? If there is a third-party funder, would he be more reluctant? Can you just give us your views from practice, maybe?
Yeah, yes, of course, happy to. Normally, well, starting from an investment treaty arbitration perspective, you could have different parties who would be the claimant, if you like, and that could either be the project company or the sponsors if they've invested. But you would really, but I think above all, you would want to concentrate all those interests and ensure that the investor side speaks with one voice. And I don't see a difficulty with that. I would have thought normally, where possible, you would make the project company the claimant. To talk specifically about lenders, they generally prefer to stay behind the scenes and not get involved in the day-to-day running. And that's fairly typical of lenders. It's really a kind of disaster scenario if lenders are actually thinking of exercising their rights to step in and take direct control. That really is something of a last resort. So I think normally project company, occasionally the sponsors, depending on, amongst other things, jurisdictional issues in the treaty. I mean, if the project company is incorporated in the host state and couldn't be a claimant, that's a scenario where it may be the sponsors rather than the company. But in any event, I don't see a difficulty in ensuring that on the investor side, everybody's speaking with one voice and there's kind of one point of contact.
Yeah, but the point is also, I
think we're running out of time. I apologize, Herman. I'd like to thank our speakers for their time, their patience, and for really a remarkable tour de horizon. I look forward to the next session, especially climate change, since time is not only money, but time is also carbon and climate mitigation. I'm sure Brooke, a friend of mine, will be speaking as well. I hope you have a good day, and thank you once again.
Thanks, Malik.